Timing is everything. I am on my way right now to the courthouse to drop off a trial binder. That trial binder contains all of our exhibits, copies for the court. They are in perfect order. There's an exhibit list, a witness list, and anything and everything we may require for trial. Hundreds and hundreds and hundreds of pages long, binder clipped properly in the exact order necessary sequentially. This reminds me of a question that clients ask all of the time, specifically with uncontested divorce. Can we file my case and then am I done? Oh no. First, everybody in an uncontested divorce must agree to all relief. All documents must be signed and or notarized and ready to go. Once we file, even with an uncontested divorce, Florida has a written law, not an unwritten law, but a written law per Florida statutory law, that while the court may, as justice requires, the court may, at its discretion, grant a divorce in a sooner time, the court is likely to have to wait 20 days from the date of filing of a case before it has the authority. Standing is different. This is more of a jurisdictional issue, subject matter jurisdiction. In fact, court has to wait 20 days before it can grant a final judgment of dissolution of marriage. Consider why that is. Why would the court want for people to have to wait interminably? 20 days? I don't want to be married for another 20 days. Maybe something takes effect in your marital settlement agreement only once the divorce has been officially signed off on by the judge. You have a final judgment, a divorce decree, if you will. Well, then people might really want to push the envelope and ask the court for relief in a sooner amount of time upon mutual agreement. Buyer beware, you do not want anything to be set aside under fraud, duress, coercion, involuntariness, and this is potential evidence of that. While yes, in an uncontested divorce, many people say, hey, we just want to get this over with. Everything's done. It's signed, it's sealed, it's delivered. Come on, Attorney Jacobs. Come on, Attorney so-and-so. Let's get cracking. Let's get moving. Okay, fine. Fair enough. I understand. I don't disagree with you, and we can do it upon mutual agreement, especially if everything is exactly as it should be. But again, if there's any doubt in your mind, and there's any reason why you believe that the other side may at some point want to set aside an agreement or might change their mind, then you had better do everything on the front end by the letter of the law. Leave no room for interpretation. Make sure everything is done perfectly, unobjectionably, from the very first moment until the very last pen stroke of the court for your case to be completed properly and done properly. There's a lot to be said for a little bit of patience. Goes a long way.